The fight over the future of suppressors and short-barreled rifles just reached a massive turning point. Not only did the court here that's already handling the silencer shop NFA challenge consolidate a second major case into the very same court in arguments, but yesterday, both sides officially went head-to-head in front of the judge during those oral arguments on their cross motions for summary judgment. The government is trying to defend the NFA and keep it in place, while the plaintiffs are arguing that now with the $0 tax, there is no longer a valid basis for the NFA. The case is now officially under advisement and is now pending a major ruling. This development follows after the plaintiffs in this case sent a notice of supplemental authorities to the court here, revealing 3 brand new Supreme Court decisions that fundamentally alter this case and deal a very critical blow to the NFA and the arguments presented by the federal government. Not only do these new Supreme Court rulings instruct courts on exactly how the Bruin analysis must be performed, but they also completely wipe out the government's favorite defenses in this case. All of this was center stage during yesterday's arguments, so let's break down exactly what happened and what is at stake while we currently wait for the court's final ruling. Now, before we jump into what is going on in this case, if you like these type of videos and you want to make sure you get them going forward, make sure you subscribe to the channel and also turn on all notifications so you get updates on these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. They've increased their civil liability protections. They've included things like 4 guaranteed attorneys for your self-defense case, a hero clause, and a lot of other things are always coming. So if you're interested, if you want to check them out, you can do so using the links down below. And right now, for a limited time, if you sign up using my exclusive code ARMSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off of the family fee. So if you've been following this channel, you will know that this whole battle started after Congress passed the One Big Beautiful Bill, which effectively zeroed out the NFA making and transfer taxes on suppressors and SBRs, and it took it from $200 per stamp to $0. Now, historically, the Supreme Court upheld the NFA strictly as an exercise of Congress's taxing powers. But if the tax is now $0, can the federal government still require registration, fingerprints, and also put in place felony penalties? That exact question is currently being litigated right now in a federal court in Texas, where the silencer shop case and now the Jensen case were combined and consolidated together before the single judge, and they were argued yesterday in front of that court. Now, leading right into yesterday's arguments, a massive shift also occurred in these cases. The Jensen plaintiffs filed a formal notice with the court regarding 3 landmark Supreme Court rulings that came down at the end of June. So you had the U.S. versus Hamani case, the Wolford versus Lopez case, and they also referenced the Landor versus Louisiana Department of Corrections. The plaintiffs are using these cases to systematically dismantle all the defenses and arguments that were put in place by the DOJ, in which they're trying to use to save the NFA. So here's how these new decisions by the Supreme Court completely change the landscape and how this case is going to go forward and how the court is going to analyze these issues. Now, when it came to the first case, as we've discussed, the DOJ's primary defense is that even the making and transfer taxes, even though they're now $0, the registration system is still constitutional because it helps to enforce the special occupational tax that is paid by NFA businesses. The plaintiffs in these cases point to the Landor versus Louisiana case by the Supreme Court to shut down this type of argument. The Landor case explicitly limits Congress's spending and taxing powers, ruling that they cannot be stretched to drastically expand federal authority. The plaintiffs argue that under Landor, forcing a burdensome registration scheme onto everyday untaxed Americans just to support an occupational tax on businesses is an unconstitutional expansion of congressional power. So in short, they argue that if there is no tax, there is no registration power. Now, the second case that they point to is the Supreme Court ruling in Wolford versus Lopez, where the Supreme Court delivered a massive victory for the Second Amendment and the type of analysis that needs to be performed under the Bruin decision. The DOJ repeatedly tried to argue that suppressors and SBRs aren't even arms protected by the Second Amendment, but Wolford completely solidified the rules for that type of Bruin analysis at step 1. The Supreme Court ruled that the only predicate question, or the first question that needs to be asked at step 1 is, really the plain text analysis, which is, does the law concern any form of arms? Here in this case, the plaintiffs note that a suppressed firearm or an SBR is undeniably a form of an arm, and regulating them plainly concerns the use of a firearm. Therefore, under Woolford, suppressors and SBRs are presumptively protected by the Second Amendment, and the entire burden then shifts to the government to prove historical justifications that they are putting in place these restrictions, and that needs to happen at step 2 of the analysis. Woolford also addressed a tactic that lower courts love to use and they've been using for a while, which is requiring plaintiffs to prove that a firearm is in common use before even looking at the Second Amendment. The Supreme Court in Woolford explicitly stated that the in common use analysis is out of place at Bruin's first step. In fact, Justice Barrett noted in her concurrence that the government cannot smuggle in regulatory limits into the plaintext stage at that first step of the analysis. This means that the court must start with the presumption that the conduct is in fact protected. Now, for a long time, the government here in this case has been trying to rely on a prior Fifth Circuit ruling in a case called U.S. versus Peterson, and they've used it to argue that shall issue licensing and registration schemes like the NFA get a free pass under the Bruin analysis. The plaintiffs, however, argue that Woolford leaves absolutely no room for these types of caveats, and they say that Woolford reaffirmed that there are strictly 2 steps to the analysis: the plain text and the historical inquiry. If a law impacts the plain text, it is presumptively unconstitutional. The plaintiffs argue that the logic used in Peterson is now invalid and must be thrown aside, and must also just not be used in this type of analysis. Now, finally, the Supreme Court's ruling in both the Woolford and U.S. versus Hamani case draw a clear line between licensing a person and registering a gun. It pointed out that licensing is about checking if a person is disqualified, where registration is about tracking the physical property. Because the how and why are completely different with those 2 structures, the government cannot use historical licensing laws to now justify the NFA's tracking and registration database. Furthermore, in Hamani, the Supreme Court rebuked the federal government for essentially trying to arbitrarily declare that categories of citizens are dangerous just to essentially disarm them. And they argue that this heavily also damages the ATF's foundational philosophy of the NFA, because that is essentially how the NFA operates. It has a broad class of items that it declares dangerous and categorically bans them. So with yesterday's oral arguments officially concluding, the Northern District of Texas is officially the epicenter for challenges to the modern NFA, now because of the $0 tax. One single federal judge is now evaluating every single major constitutional flaw in the NFA, armed with these brand new Supreme Court rulings as well that were submitted to the court. The court is actively reviewing whether registration can survive without the tax, and the plaintiff's framework is heavily backed by the Supreme Court's latest decisions in cases like Woolford and Hamani. Because the motions for summary judgment are now under advisement, a final ruling from the district court could drop, very soon. And these are cross motions for summary judgment, so depending on who wins, no doubt this will be elevated eventually to the Fifth Circuit. So I'm going to be monitoring the docket closely to see, how does the judge rule on these issues? What is the analysis that he performs, and what ultimately does he say about the NFA as it currently stands in light of the new $0 tax change? And once that happens, I will bring that to you immediately. So if you found this video helpful, if you want to make sure you get these videos going forward, make sure you like, comment, subscribe, and turn on all notifications like I mentioned to ensure that you get these videos when I release them. Also, let me know in the comment sections, how do you think that these cross motions for summary judgment are going to play out? Do you think this judge is going to rule that the NFA structure can now not stand because of the $0 tax? Or do you think that he's going to continue to agree with the federal government saying that the NFA operates like a permissible shall issue system? Again, let me know your thoughts down below. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.